So my goal here today is to help you figure out how to help your clients and your family members if you end up in a system that you didn't expect or that you purposefully want to use as part of your toolbox, and how to do that. In New York State, the law prohibits asking the victim whether the arrest should be made and prohibits threatening arrest for purpose of discouraging police intervention. What that means is you cannot say to a family member of someone who might have schizophrenia who is acting out, "Do you want your child arrested?" You are prohibited from asking that. The authority of law enforcement is now to make the arrest without asking. If a loved one says, "I don't want him arrested," or volunteers that information, or somehow tries to ask for other interventions, the police have a little bit of discretion if it's in a pro-arrest community. But if you are in a mandatory arrest community, the police have very little discretion like they used to have some time ago. In some ways, when you have a family member that is diagnosed, you remember the moment in time and the clock stops for you. You have a life before and you have a life after. I've just conducted interviews with people who lost a loved one to homicide. We're now doing focus groups with people who have had a loved one who had committed suicide. And their narrative is the same. They will tell me, "I had a life before and I have a life after. My life after is consumed with the following," and they will list all the things that consume their time post-diagnosis. And that's also true for people who are diagnosed with health issues, cancer, and other sorts of events in their life. But as you've heard today, the clock doesn't have to stop, and we don't have to have that moment freeze in time. And even if we find ourselves embroiled in a system that we didn't anticipate, there is still some hope. This diagram, Steve is in the room. Steve and another colleague of mine, Mike Privatira, and another gentleman, Don Kamen, were really struggling in a meeting one day about looking at how the criminal justice system responds to individuals and when discretion becomes possible. And what I learned with our case from this morning's narrative with urinating in the park, that would be a very low level of criminal behavior. It wouldn't be very serious. And perhaps at that moment, our young man was not exhibiting terrific symptomatology, and maybe the police mistook him for someone who was intoxicated. In that lower left box, there's a lot of options. The police can say, "Stop doing it." They can just talk to the person and say, "Move on." When we heard the mayor on our video this morning who said shopkeepers are getting angry that somebody is homeless and mentally ill in front of their store, the police don't have to make an arrest. They can simply say, "Move on." Or they can issue an appearance ticket, which is a piece of paper that says you have to come in on this day and time, which is ridiculous because, as we know for many of our clients and family members, date and time don't really matter in their world at that moment. They are likely to miss that court appearance, which will result in a bench warrant, which will then make the matters much worse for them. All the way to interventions, diversion programs, and then there becomes this area of controversy looming in the top right box that we heard about this morning, which is, what do we do with someone when they are seriously mentally ill and they have committed a serious crime? And that area of controversy is difficult, especially if the person that is the victim of the crime is a loved one. And that loved one does not want to be involved in a system that is high conflict, adversarial, and they become part of the process of convicting their loved one. I purposely put this sideways. It's to make you all sort of feel a little off for a moment, because this is how I kind of feel every day when I'm at court. If you end up having someone who is arrested and put into a court situation, you likely, even though you may have been the victim and complainant, are the person transporting them to and from court and arriving with them and preparing them for court. Unlikely in the case of a bank robbery, where you would not have a teller driving the robber to court. It puts us in an awkward position. When you think about preparing for court, it is a very chaotic place. When we think about emergency departments, that's what court seems like to me. Often things are urgent, emergent, and operating behind schedule all the time. There are long lines to get through. Once incidents started happening at court, we went to metal detectors. Some courts require people to take their shoes off. Metal detectors require you to remove your belts. For those of us who are used to air travel or other situations where we have to go through this sort of surveillance, we're a little bit more comfortable with that. But when you ask somebody who is having audio or visual hallucinations or other types of thoughts, they're going to want to know why they're going through a machine and what that machine is going to do to them. And why do they have to take their shoes and their belts and other things off of them? And it can actually cause a great upset before your family member or client even gets into the courtroom. It's not just that going to court becomes the ordeal. It is the process of getting into the building that becomes the ordeal. So how can we think to prepare for that? It might mean not wearing belts. It might mean not having overlays of clothing on that need to be removed. Walking through the courtroom and through these metal detectors makes you feel like the criminal. Even though you may be the advocate, the counselor, the caseworker, the family member, the advocate, the friend, or the client, you automatically feel like a criminal regardless of your purpose for being at the courthouse. Court is routinized. It operates every day without you there. You being there often makes no difference to the people who work there. You don't know where to go, where to stand, where to sit. How do you know when your case is going to be called? What if you don't hear it? Do you miss your opportunity to talk? Where do you sit once you get called in? When you're inside, are you allowed to talk? What if I have a grandchild I'm the primary caretaker for? Can I bring my 3-year-old to court while my son is facing criminal charges? What do I do if I don't have daycare? These are questions that everybody faces. Many courts now try to reduce the stigma and the mystery of court by posting these things very well on the internet. Until just recently, I was one of the supervisors of an on-site daycare at our court, free drop-off center for kids whose families were involved in the court system. It made it much easier for families when daycare didn't become an obstacle to that process. You often feel very isolated at court. You're there, you really don't understand the process. Unfortunately, your child has an attorney assigned to them and you don't even know that attorney's name and they haven't met with their attorney yet. So you're often sitting there alone. There is stigma assigned. You might have to lose work. Your family or loved one may be losing school time, missing exams, having to explain why they're missing time. And then there's always the issue of parking. At our court, parking is $8 a day. That's a lot of money for some people. That's a lot of money for most people. And the public transportation system option, which might be $1.50 or $2, requires that you and your family member or your clients change passes 3 times and have to go a circuitous route to get where if they had driven their car, they could have made in 10 minutes. Directions are often confusing. There are personal agendas that you're not even aware of. There are what we call courtroom work groups that form. You may see the prosecutor speaking in a jovial manner to your loved one's attorney out in the hallway. You can't understand how the person advocating for your loved one is friends with the person that's trying to put them in jail. And we don't always understand the politicization of the court system. We don't understand how people who are running for office can have their supporters or donors or sponsors in the courtroom with them. So it becomes a mystery and a place to me unlike most others. But I believe that court can be different, and I believe that the courts can be a venue for public health promotion. And the courts that we spoke of earlier, veterans courts, mental health courts, domestic violence courts, DWI courts, are all a move in that direction. The movement is called Therapeutic Justice, and the goal of Therapeutic Justice is that everyone, including the defendant, leaves court happier, better, and healthier than when they got there. For your clients or family who have sensory overload issues, court is overwhelming. When I get calls for people who want to volunteer with my team down at court, I tell them, I would love to have you volunteer at court. Why don't you come and spend a day watching before you make that choice? And I would say we lose about 30% of our volunteers. They have no idea what court is going to be like. I'll give you an example of stepping off the 3rd floor elevator in my building. You get off the floor, the door opens. You hear screaming, yelling, crying children. You smell dirty diapers because your elevator's overcrowded with families with strollers who haven't had a chance to put a new diaper on their child yet. You step off the elevator and you see what appears to be the Jerry Springer talk show setting. You cannot believe what's happening on the floor. Sights, smells, fears, sounds, the very feel of being there. Gum on chairs, chairs that are missing arms, mismatched furniture. For people who might be having OCD issues, sitting in a room like that is just overwhelming, besides the fact that they're there for court. So in order to prepare for this, you need to be working with your counsel to ask for things like early dockets or later dockets, find out when court is quieter, when is there better parking, and just kind of figuring out the logistics. What makes this the most fun is that all the courts that work in this building, we have family court, visitation court, custody court, Supreme Court, which handles divorces, criminal cases, civil cases, trust and estates, adoptions, misdemeanors, felonies. Everybody has to walk through that one door. One door. Why? Because it made sense to centralize security. But what happens when you have everyone walking through one door is your 400 or 500 jurors who are also summoned also have to walk through that same door. But again, I believe that court can be a place for mental health promotion. We started in our community one of the first mental health clinics at the courthouse in family court that we know of in the country. Before we started our clinic, 1 in 20 victims were linking with mental health care, despite 70% of them having depression, 40% of them having PTSD based on symptom scales. Nobody linked with care because it was too overwhelming to connect with the mental health system. By creating a mental health clinic at court for victims, our linkage rate is now 1 in 2. And what made the difference? The Therapeutic Alliance. They were connecting with a psychiatric social worker right there at court and built that relationship, that trust, and we're then able to follow up with care in an expedited fashion. If you hand them a phone number before the introduction of our court clinic, they would call that number, and unless they were in an emergent situation, they might have that 3 to 6 week we heard about earlier today. Now there are slots preserved for the folks that are coming from court. When we ask people, did you use the police, would you use them again, why would you not, why would you, the answer is usually no. And that's because the criminal justice system, unlike Law and Order and Special Crime Victim Unit, NCCI, or whatever it's called, it doesn't wrap up in an hour. You have a crime that's committed at your home, you call the police, and they report to the scene. They decide that they're going to investigate, and they may not do anything, or they may decide to make an arrest. Each of the white spaces you see up on the screen become an opportunity for the case to fall through the cracks, meaning it gets dropped, it falls off someone's radar screen, it doesn't get followed up with, there's missing paperwork. Once the charges are filed, if it's a misdemeanor, it moves out the bottom and might be diverted. It might go to a day treatment program, mental health treatment, or some sort of specialty court. Then there's the initial appearance, and misdemeanors are lower level crimes. The normal definition is less than a year in jail. Or it might be a felony, which requires a preliminary hearing to have the evidence that the prosecutor has enough to move forward. Now, in some communities, the crime to the first appearance can happen very quickly. Some laws require it to be 72 hours, sometimes it's weeks. But in small towns, if you live in a rural community, I was a rural prosecutor for a while, it could take you 3 months to move from crime to an arraignment, to an initial appearance. So when your loved one gets arrested or your client gets arrested and they're confused and don't know where they are in the system, that's why, because it is confusing. Once there's a preliminary hearing, they decide whether there's bail or detention. If it's a felony, it moves to grand jury. Many defendants will think that grand jury is the trial. Well, my case went to trial. But unfortunately, that is the beginning of the system. That is where citizens decide whether there is enough for that case to proceed to the next stages. If you are the victim in a criminal justice case, your testimony may be required at the initial appearance, preliminary hearing, and grand jury. So as a victim, you've now told your story many times over. Once you reach the point of a case being arraigned, the charges can be dismissed, there can be a guilty plea, you can move forward in trial, and then there's sentencing. And with the sentencing comes potential incarceration, probation, jail, prison, if it's going to be more than a year, and then eventually out of the system. The problem is, for our clients, they come right back in again, unless we make this a meaningful experience and get them connected with the right courts, the right prosecutors, and the right venues. Each of these stages is an opportunity. If you don't have a mental health court, you may have a specialty probation department. If you don't have a specialty probation department, you may have someone in a parole situation that you can speak to. But you don't want to walk this road alone because it is overwhelming. And as long as I have been working within this system, I still often don't know where to start. You want to think about specialty courts based on therapeutic justice, whether there's a mental health court or a veteran court, and whether your particular client or family member meets the criteria. Now, if someone says, well, your case doesn't meet our criteria, the conversation doesn't stop there. You ask, what is the criteria? Is the criteria that it not involve an injury or an assault? Or is it a certain level of crime? And the reason you want to know that is because if you get involved in the system again, you know the right words to use and the questions to ask. You also want to go above the head of the person who's giving you the answer you don't want to hear. Everybody has a boss. And in most communities, your prosecutors are elected. If you don't like the question and you don't feel the office is responding to a particular community's needs, you have to open a dialogue with the head of the office. There are special policing units that we're going to hear about. Do you have one? If you do, when you call 911, let the 911 officer know that you're dealing with someone who has a mental illness and you need a special unit assigned. We call ours emotionally
EDPRT.
Emotionally Disturbed Response Team. So each community has its own buzzword, but you need to know the buzzword. It's like knowing a foreign language to know what to tell the 911 officer. You want to be prepared with the statute numbers and resources. If somebody comes in to make an arrest and you want a mental health arrest, know what the statute numbers are. You can Google them. They're on your state assembly and Senate web pages. Know the numbers of the codes that you're seeking relief under, because then the police know you know what you're talking about. And if you're not happy with a police response to your home, you call and ask for a supervisor. I always tell everyone, they have a boss. If you're not happy with them, they work for you. Your taxpayers pay their salaries. You call and ask to speak to a supervisor. Remember that the employees that you're encountering are just like all of us in this room. If we know that the rate of schizophrenia is about 1 in 100, out of 100 people working in the courthouse, somebody has a family member. If we know the rates of depression and PTSD and child abuse and sex assault histories, chances are many of the professionals we're encountering have a sensitivity to this issue. It's a matter of finding the right person to speak to. And remember, the option of family court is always there. Some communities call it civil court, family court. In our particular community, if I have a family member that I feel harmed, threatened, or annoyed or alarmed by, I am able to go downtown and file for a protection order in that court. I do not need to call the police first. I do not need to have a police report. I simply make my claim and I can ask for certain types of relief, which could include a mental health evaluation, a drug or alcohol evaluation, and it provides that legal leverage that Steve was talking about earlier in a different venue without needing to escalate it to the police being called to your home. It's a very viable option sometimes for some. This is a diagram of cases in a particular community where the police came and made calls for service. That's in the first box. If you have a call for service to your home, don't lose hope that your child will end up incarcerated for the rest of their life, because you can have hope. Many cases that come into the criminal justice system, in our particular study, 21% never made it past the front door of the district attorney's office. Once it made it into court, 15% were dismissed, and then another percent were found not guilty, and at the end of the day, many didn't make it into the system. So even if you have someone who's been arrested, don't lose hope. As I showed you, that long chain of events they have to get through, arraignment, prosecution, discovery, trial, plea bargaining, dispositions, a lot of cases, even though there's an arrest, don't make it past that stage. What you want to be sure you're doing is engaging with counsel, talking to your child's public defender, and trust me, public defenders have huge caseloads, and I know that. They are in court from 9 to noon and from 1 to 5 and sometimes at night. So when is your window or opportunity to talk to them? Call during the lunch hour when they're literally eating lunch sitting at their desk, or fax them a piece of information, email them, send it in the mail, drop it off, get communication to them however you can, because they're going to be your client's front door. It's important, if you're involved in the criminal justice system, to really be connecting the criminal justice system with your family member, loved ones, health providers. They need to know that your client or child is under supervision of a healthcare provider, doctor, primary care doc, psychiatrist, psychologist. Get them talking to each other. You also need to be thinking about what financial resources are available in terms of housing, job training. And when the judge puts diversion as an opportunity, that diversion could be getting your GED, going back to school, securing housing. There's lots of options. We want to think about how children fit into all of this. Some of these individuals have children, and while they're involved in the criminal justice system and temporarily incarcerated, we end up with kinship care situations where all of a sudden now, I as a grandmother am taking care of my child's child. I have no legal paperwork to do that. You might want to arrange with a family court attorney to get temporary guardianship over that child so you can make decisions and engage with the school providers and counselors in the way that a parent can. And don't forget about the faith-based systems. Many faith-based systems offer programs for defendants. They can help defendants with many of these other domains we're talking about, and they have a real commitment especially to reentry programming. And at the end of the day, in working together as a system, I do believe change can happen, but people have to be talking to each other. Some helpful resources for you are looking at the Victim Bill of Rights. If you're the complainant and you're the victim in a particular case, that Victim's Bill of Rights applies to you. You might utilize the victim service units. They spend much more time at their desks and reaching out to people than the attorneys do. You might want to engage your social worker or caseworkers in the communication. It's very different if someone calls and asks to speak to the prosecutor in a professional capacity than a family member, unfortunately, sometimes. You want to think about diversion programs, day reporting centers, attorneys with specialty practices. We are very fortunate in our community to have attorneys that know the areas of law and the intersection between criminal and family law and disability law very, very well. That is what they do. And you also, when all else fails, may want to call the newspaper. And that, some fear, is playing hardball. We had a case where a young woman who had some mental health issues was about to be arrested, and the police had failed to make an arrest on 12 occasions when she had been the victim. And I said to the police, feel free to arrest her, but when you do, we will be there with the press in the courtroom with the 12 reports that you failed to make the arrest on her behalf. And it was very effective. When we think about mental illness, I share this picture or diagram with you because this is an old photo that we used to use when we talked about domestic violence and family violence. And these photos were always in the shadows, they were always in the dark. It was largely pictures of women who had bruises and sad faces, and it adds to the stigma. When those are the posters you see in the OB-GYN offices, you're not inclined to pick up the phone. These are the pictures that we want to be seeing now. We want to see people going on and leading productive lives, and I believe that the messaging, the words we use, the pictures we use, the posters we put up, all become part of that messaging. These are just a couple of people that I want to thank. And before I speak to answering any questions that you may have, I just want to really personally thank Linda and her husband, Russ, who have been the real movers and shakers for not just SARDAA, but for this conference. And I work on conferences a lot, and I do annual meetings, and I help with galas. I have never in my life ever tried to do all three in 48 hours, which is what's happening here. So many thanks to you guys so much for all that you've done and all that you do. And before we open it to questions, for those of you who feel like this has been helpful to you, think about SARDAA, and if you're local or far away, the contributions you can make, the gifts that you have, the talents and resources that you have to help the organization continue to spread this message. The presentations from today are going to be put on an internet site where people from other communities are able to then share them with other individuals trying to help the field of mental illness. So now I have 10 minutes if anyone has any questions. Yes?
In our town, they have something called a patient's rights advocate that he goes to court for. Is that a term that's widely used? Is that a position in other areas? Or?
I'm not familiar with how widespread that is. If anyone else in here wants to speak to that, I have heard of that position before. That's why I was recommending that the attorneys and caseworkers talk to each other, and that patient's advocate would be one of those people you'd be wanting to connect with the legal side of the fence. Yes?
I have a question. In Houston, there is a mental court. I have a question about this court. Is the referral from mental court in Houston considered to be, when the officers come and pick up the person, considered to be an arrest or not?
The question is, when you're talking about mental health courts, is it considered a mental health arrest or not? Based on my knowledge in the communities that I work, mental health courts address criminal arrest behavior, where the police have initiated a criminal case against a defendant. Mental hygiene arrests are in many communities adjudicated in a different court forum. It might be a surrogate's court or Supreme Court situation. In order to get into a mental health court, there is a criminal charge that has been filed, and that criminal charge, depending on the community inclusion criteria, would be a misdemeanor or a felony, or both. The goal is to have that charge be waived in lieu of treatment, resources, and recovery. It is to keep the person charged without being stigmatized with a criminal record moving forward that might prohibit schooling, licensing, or job opportunities. Mental health courts have a real strong foothold, I think, in the United States. You can Google those and get on the internet, and you can get some of the most recent reports that have come out on their efficacy. There are basic standards that are expected and basic protocols that are followed, but the local nuances can't be understated. A lot of it has to do with the commitment and drive of the judge. The judge in our particular community was passionate, respectful, empathetic, and ran a phenomenal mental health court that celebrates with graduations and reducing stigma activities. So it really varies by jurisdiction. Any other questions?
Could you elaborate a little bit on the volunteers in the court? You said you had volunteers that would come to
Yes.
court.
The question was, can you elaborate on volunteers that come to court? We use volunteers in our program. I work at a psychiatry department at the University of Rochester, and our Department of Psychiatry has several initiatives happening at court right now. One, Dr. Lamberti has a randomized control trial in looking at effective community treatment. There's another doctor who is running a randomized control trial looking at linking female defendants who are at risk for HIV or AIDS with physical and mental health help. We just finished a randomized control trial with linking people with mental health help in the DV court. We run a daycare, and we also have a mental health clinic at court. All of those venues, I think with the exception of Steve's, had ample opportunities for volunteers. They volunteered through the Department of Psychiatry to provide daycare, to be helpful with the research projects, recruiting. We also run what's called Promote Health. It was created by Dr. Karen Rhodes, where court consumers can take a survey and it prints out a public health list of their issues with free resources for them. We had volunteers running the Promote Health surveys for a while. We use volunteers a lot. Without them, our programs wouldn't really happen. I believe volunteers are the backbone of most movements. Yes.
Yeah, I'm interested in the mental health clinic at the court.
Yes.
And the person goes before the judge and then is recommended to go to the clinic. How often do they include the family, as in recommending, like, they deal with the family therapist as opposed to just the person?
Okay, the question was about the mental health clinic that we're just opened and we're running at court, how it operates with inclusion with the court system and with the families. Our mental health clinic is for victims. So they cannot be ordered by the court to do anything. So when a victim comes to court, so if a mother has pressed charges against her adult son and she's come for a protection order, she would be then approached by the psychiatric social worker while she's waiting for court to be called and asked about her mental health needs, depression, anxiety, etc. The needs would be assessed right at court, and then a referral would be made, and that referral could be to a whole host of sources. It may be back to a primary care doc, it may be an OB-GYN, it may be a therapist. We have psychiatrists with slots open if we need a medical evaluation or a psychopharm evaluation. We have a licensed marriage and family therapist. Some victims will say, I really want to see a counselor, but I want my kids to come too, or my whole family needs therapy, my husband has a mental illness and it's affecting all of us, and we'll link that family up with marriage and family therapy services. So that clinic operates as a linking mechanism, and the psychiatric social worker there actually got her training in an emergency psychiatric setting. She was part of our what's called CPAP. So she's used to being in an environment like that. She was the third. She has now stayed long, but before we got her, we had 3 people come in and try to do that job and just could not handle the court environment, even as the professional, not as a consumer or a defendant. So it's just being written up now, and we're really excited about it. We started it with an education grant from the state that was interested in training mental health providers to do more community engaged work. That grant is now up, and we have scraped together resources to keep it operating, albeit less hours, but the door is still open. So, any other questions? Time for one more?
What about privacy in court settings? Because I understand that if you bring in somebody's mental health history, that becomes open court. It can be in the newspaper and all of that also.
The question was, how does HIPAA interact or privacy interact with the courts around mental health records? That's really case dependent and court dependent. So in family court, if a woman who is mentally ill is being brought to court by the county to have her parental rights terminated, the family court will be, the judge will sign a subpoena to the mental health facility to provide those records. There are ways to challenge those subpoenas, but in certain circumstances, especially where child welfare is involved, we have little or no standing to try to not provide those. People who provide mental health records to the court can do so in a limited fashion. There could be specifications that those records not be shared beyond the team. There could be requirements that those records are given to the judge, who reads them what they call in camera in his or her office and then decides whether or not to release them. That's very different than criminal court, where criminal court is open access, open to the public. If there is a defendant who puts on a particular mental health defense, that's open to the public. Most documents that are entered into evidence are open to the public. The court record becomes public under the Freedom of Information Act. So it really depends on the circumstances, the court, who the players are, and how the criminal justice or civil justice professionals obtain the information in the first place. So that's a varied question. And thank you very much. Keep up your good work, and I'll be around today and tonight if anyone has any other questions. Thanks.